3-4 minutes, but I'm just gonna,
Oh, yeah.
just so I'll
No,
forget,
I
I'll
was.
forget it. I'll absolutely forget it.
So, my husband and I are huge college football fans, huge
Oh, really?
Pac-12 fans,
Really?
and he's excited about the
You
UCLA
guys, you guys, Oregon State killed us the other week, like 2 weeks ago. They killed
Yeah,
us.
we went to U of L, so we're big Ducks.
Yeah.
But I mean, can appreciate
Yeah, yeah, yeah.
Comet. What position did you say?
He's a wide receiver. Yeah, wide receiver. He's excited. I mean, he was a quarterback in high school,
Yeah.
and this spring, he asked there was a guy that he really high on for quarterback, so he asked if he can move to a different position to get an opportunity to play. And he's worked his butt off in a new position
Yeah.
and climbed. I think this week they brought him up from scout to play back up to one of the second string wide receiver for the most part. And so he's worked his butt off, and we're just grateful for this season where God's kind of shaping him into what he needs to be. So through adversity, you know.
Yeah,
So
no, absolutely.
hmm
How you
yeah,
learn and grow and
yeah,
so
absolutely,
good.
absolutely. Right before we left, he wanted to possibly leave and go to another school, and we just said, but right before he started school, in fact, 2 weeks before, and we just said, um, yeah, let's just spend a year,
Yeah.
and you actually just learning a new position and really being shaped into something special. And so he's done well. He's doing well.
That's awesome. That's awesome. Well,
Done
I'll have
well.
to watch to see.
Yes.
Okay. Okay. Good morning, welcome everybody. I'm going to get started here. Just a few housekeeping items before we start. We are live streaming this session as well, so please, if you could refrain from walking in front of the camera and or talking near it. And then also, if you could, again, similar to upstairs, limit your use of Wi-Fi if at all possible, so that we can get consistent streaming. And then another piece, any of you who did not have the opportunity to hear Ed's first session, which was pretty amazing, and did not have the opportunity to get one of these handouts, we do have extra. Is there anybody here that does not have a packet? Raise your hand. Okay, awesome. Well, we do have extra as well, so if you would like to take some back to coworkers and or team members, feel free to all be up there in front. And with that, it's my pleasure to introduce again Mr. Ed Norwood. Thank you.
Thank you very much. Thank you. Thank you. All right. Well, it was such a poor applause right now. I'm just really, I just feel full. I'm kidding. I'm messing with you. I'm so messing with you. I'm trying to pull something up to tell you right now, and I can't find it. That was buying me time. All right, I have it. There it is. Just found it. Well, thank you once again. We had a great first session. You've been just great. Your group has been great. We again, just a bit of housekeeping. On LinkedIn, if you follow me on LinkedIn, we are engaging in fights with Medicare Advantage plans. I'm going to be listing on LinkedIn some new Milliman and Interqual guidelines, disclaimers that you can use when challenging plans that um, deny based on the guideline, but have not conducted an independent qualified healthcare professional review of the care. And so I want to show you how to use that. I encourage you to follow me on LinkedIn. I'll post something on that this weekend, just so you'll have the ability to use it. I may even do it by tomorrow before I leave out of town once again to Missouri. We've been talking about giants upstairs, and just before I started, I heard a funny story of a man who went to the doctor with his wife, and the wife pulled, or the doctor pulled the wife to the side and said, "I need to tell you something. If you don't do these three things, your husband is not going to make it. He's going to die. And the condition he has is very, very rare. It's important that you do these three things. You write them down, you pay attention to them to make sure he lives, so he can see your grandkids and see your kids get married and so forth. And he said, number one, every day I want you to make sure you fix them a 5-course meal. It needs to be 5 courses, no less than that. Ensure that you include some of his favorite items in that particular dinner on a daily basis. After you get home from work, after your 8-hour day, I need you to make sure you do a 5-course meal for your husband. Number two, I need you to satisfy his every whim. Whatever he wants to do. If he wants to watch football all week long, not mow the lawn, not do any housework, just you make sure that everything he wants, he has. If he wants a man cave, give him a man cave. If he wants a particular truck or motorcycle, make sure you give him everything his heart desires, even if it's at the expense of what you desire. Number three, she said, he's not to do any household chores anymore, not to fold any laundry, not to go outside and mow the lawn. He is to be chore free in this household to make sure, I'm telling you right now, if you don't do these three things, he's going to die. And so the doctor, the man is driving back with the wife, and he asked the wife, what did the doctor say? She said, you're going to die. You're dead, sucker. You're not going to make it. Let's go do the will. Let's do that. What happens when we say no to health plans? Write this down. Just say no. Just say no. Just say no. One of the smallest words in the English dictionary, no is a powerful word. It will help you choose and refuse things in your life. To draw a boundary line in your hospital delivery system, healthcare delivery system, or your peer-to-peer review process, your concurrent appeal process that declares to giant problem payers no far and no further. The word no will strengthen your influence. It will grow you professionally. It will instill preventative measures with payers that you deal with on a daily basis, so that when plans see your name, they won't even think about sending you an improper medical records request. They'll say, oh, that's that particular provider. They're going to quote some law. They're going to file some complaint. Just pay it. Just resolve it. Don't deny it. Why? Because no creates boundaries. Every human body every cell in the human body is protected by the cell membrane or its boundary. And like our cells, we have to have emotional and professional boundaries that keep us operating at our very best, that protects our patients from careers from injury by improper plan denials. Write the word boundaries down. Boundaries, emotional boundaries are really, really important. In this season of my life, I'm learning the importance of making sure that I don't create triggers for my kids, my adult kids. We've just gone through an empty nest syndrome, and it's the worst thing ever in life to go through. I want you to know that. And about a year to the empty nest syndrome, my wife was asking me, well, what are you going to do when, the last kid was Josiah, when he goes to college? It's going to be exciting. He's going to be playing football and getting his degree and becoming a young man. I'm so excited for that. And within months of that, I was in tears. I had tissue everywhere. It was a very difficult process because you spend so much of your life having the identity of an in-home parent. Then all of a sudden they're gone, and you have to figure out what to do with yourself. You've got to rediscover the other person. And, and throughout life, I remember going through things with our kids, and I'm learning now in this season the importance of not creating triggers with our kids, not crossing certain boundaries. I remember when my son was 16 years old, and he's the one I had an issue with the curfew. He just didn't want to come home at curfew, and something happened, and I yelled at him, and I took his shirt, and I took it, and I put it against the wall, and my other son grabbed me, my wife pulled me to the ground, everyone was crying, and I was rocking this 6'1" guy that I put against the wall in my arms saying, Daddy's so sorry. I'm so sorry for doing that. I can't believe I did that. Will you ever forgive me? And when he was around 20 or 21 years old, I remember he was sick and he had to go to the doctor, and I began to get really stern with him. And literally, I saw him and heard him on the phone shrink. And I knew I had created a trigger for him just from something that I had done years ago that I had apologized for, but I knew I was recreating that. And so in this season of my life, I'm learning the importance of uncovering certain things that I may have done to cross boundaries when I was upset and let the anger get the best of me, or did something that I felt that was, embarrassing to them when they were actually little. And I'm saying, hey, when you were X age and dad did this, that was anger. That was pride. That was so, I so hate I did that. And I want to just apologize to you. Will you ever forgive me? Because I realized that I have to deal with the boundaries that I've crossed later in life, because our kids carry things that happen to them in life. Did you know that a child determines the way they observe things and think by the age of 5 and 6? It's a true stat that's out there. And so I'm learning more and more the importance of making sure I pay attention to boundaries. Because when you have adult kids, it's easy to cross boundaries. Because you live for 40 or 50 years, 60 years, and you know that there are certain things they can do differently, and you feel that you want to cross a boundary, and it could be dangerous in that environment. Why do I say that? No creates boundaries for payers. Where we may not want to create boundaries for certain people that we love, or may not want to cross those boundaries to respect them. We want to give great respect to payers, but yet realize that we have to create boundaries to ensure we're protected from improper actions or things that can injure our patients. Write this down. No liberates you. Yes commits you. Sometimes providers don't want to push back against payers in certain concurrent or prospective denials because they don't want to rock the boat. They have a contract. They don't want to threaten the relationship. Because in society, we try to please others by saying yes all the time. But every time you say yes to something, you say no to something else. Every time you say yes to an improper medical records request, when you can see that contact was made, the payer failed to respond within 1 hour, it's deemed authorized. You say no to timely reimbursement capture. Every time you let MA plans give you tracking and reference numbers and not convert them to an authorization. Every time you commit to change an inpatient to observation after patient discharge without concurrence by the treating physician, you say no to federal laws that are designed to help protect beneficiary access to care. And so the question I have to you today is, what are some of the things you've said yes to payers that you should have said no to? What are some boundaries that you can create from the first class that we discussed that will change and transform how you challenge issues with payers moving forward? Here's another great question. What is your why in healthcare? What is your why in healthcare? Why do you show up every single day? Our purpose and passion is to inspire providers to advocate for medically appropriate healthcare nationwide, to inspire you to show up to work every day as if you've never failed. Please write this down. We may not be 100% in appealing denials. We may not be 100% in appealing denials. We may not be 100% in appealing denials, but we fight each denial as if we had never failed. Does that make sense? Our resilience has to fight each denial as if we've never failed. And to do that, we have to have two things. I believe you have to have passion to be in healthcare, but you must also have great conviction. Write the word conviction down. because passion is not enough. When passion leaves a relationship, it's conviction that keeps you planted in the relationship. It's conviction that keeps you showing up to work every single day in a hostile environment. When passion leaves, when you don't want to go, it's conviction that makes you show up over and over and over again and shine in a very dark place. A 4-year degree will give you information, but it will not give you conviction. Conviction is powerful. It is profound. It is conscience awakening. It awakens the purpose of your why in healthcare. It's the voice that speaks when everything around you is screaming to be silent. Conviction convinces you to do the right thing. So what is your why in healthcare? I want you to write this down and fill in the blank. I will do this blank no matter what. I will do this, put a blank line there, no matter what. I will do this no matter what. What is your this? Fill it in. I will fight for patients and providers. I will fight for justice no matter what. I will continuously improve processes in my organization no matter what. I will advocate for medically appropriate health care per WIC line versus state no matter what. What is your purpose, your why in healthcare? Lego's purpose is to inspire the builders of tomorrow. And that purpose alone inspires workers to show up to work every single day. It has nothing to do with money. It's just talking about inspiring your little toddler, our little babies, taking Lego and becoming the builders of tomorrow. For a moment, think about what your purpose is, your why. Why do you show up every single day? We spoke earlier about how we exist to defeat giants in the industry. And today I want to talk about 5 things that Medicare Advantage plans don't want you to know. We talked a bit about them earlier, and I'll continue on some of them here. But here are the 5 things we'll discuss. Number 1, the Freedom of Information Act. How to use that. Number 2, timeframes for post-stabilization. Number 3, how CMS views treating doctors as the plan. Number 4, peer-to-peer timeframes. And number 5, how concurrent patient denials must be transferred. And then I'll break down a little bit of what we've gone through earlier, a little bit more in this session so we can really grasp it and understand it. Number 1, the Freedom of Information Act. That's our FOIA request. If you're having difficulty getting MA claims paid or resolving issues with the federal government, more than likely it's something you didn't do or didn't know. When a provider bills, payers often want substantiation, implant invoices for supplies. They want you to substantiate what is being charged. As advocates, we too have the right to demand substantiation for a payer's action or inaction. So we talked earlier about how we cannot just cite the law, we must ask great questions with the law. We understand that a payer under existing federal law has how many minutes to respond to a request for an authorization? 60 minutes to respond to a request for authorization. It is not a request for a tracking and reference number. It is a request for an authorization. If a payer fails to respond to that request and does not deny care, and the patient is discharged, they're responsible to pay you for admission to discharge. Sometimes you have plans nationwide, different places, where they'll say things like, hey, we need you to notify us of admissions within 24 hours of the patient being admitted. For instance, in Arkansas, there is a law that states that the providers must notify payers within 24 hours. In other states, that does not exist. So in most states that don't have a time frame, you're required to make notification upon the patient being stable. not 24 hours, but when they're stable. Under existing Medicare Advantage law, who determines stabilization? Doctor, treating doctor, very good. Pursuant to what law? You wrote it down earlier. 42 CFR 422.113. What? B3. B3. B3 determines when the patient is stable. So when a payer states, we determine the patient was stable the day before, you can begin to create questions for your staff members to ask payers in certain denial scenarios. Here's a great question. Please provide the statutory authority you rely upon to substitute an off-site physician's medical judgment for the treating doctor's judgment of the patient being stable. You can create questions that create long, awkward stretches of silence, but also that make the payers substantiate what they're doing. Let's say if they ask you something or say something to you and you're not aware of where it is under the law, if they can do it. You can simply state this, write this down, pursuant to what law? What law states you can do that? And it's important to understand that because we're trying to build an enforcement environment within your organization through you. The Freedom of Information Act is a law that gives you the right to access information from the federal government, to keep you in the know about the government. You can ask for it in a narrative form, in writing. You can send it through to their FOIA office by email, and you can request it in an electronic format, a written electronic format, so they don't charge you. You can do that. Here's the law, 5 USC 552. If you have your cheat sheet from earlier, just insert the word FOIA request and then put that law there. If you were not in the first class, in that envelope, I've given you a cheat sheet you can pull out that will talk about, that you can list this law to discuss how you write a FOIA request. Some of you, I did not receive your registration form for your PDUs. You can give that to me at the end of this session, and I'll take that back to our offices to make sure that we record your hours. So just real quickly, here is an example of a FOIA I talked to you about earlier today that we requested with CMS. And we were requesting any written CMS policy, procedure, manual, or document that directs CMS regional offices how to review and investigate complaints against MA plans that contract with providers. Because the CMS was stating, we don't get involved between a private contract with the provider and the plan. And we reminded them, okay, you may not be a party of that contract, but you are a party of the contract with your Medicare Advantage plan that's governed by, write this down, 42 CFR 422.504. 42 CFR 422.504 is the section of law that governs the relationship of CMS and the Medicare Advantage plan. And so we found it very difficult to believe that a Medicare Advantage plan could contract out of responsibilities just by being in contract with you. So we requested proof that that existed. How they investigate complaints by contracted providers. Sure enough, they gave us an account manager SOP. You can write this down because I can't show it to you, as I shared with you earlier. Account manager SOP, section 5.3.2. You can write a FOIA saying, please provide an electronic written copy of AMSOP that outlines how CMS investigates complaints. And they'll give you the entire copy. And you can remind CMS when you're engaged in filing complaints of the importance of them adhering to their own standard operating procedure. And so you have a right to request documents. There is, we were talking earlier about how peer-to-peer review timeframes have been a topic of discussion recently, where plans are stating that they can give you a certain amount of time to actually engage in a peer-to-peer review. We've also seen recently that plans are attempting to do 6-year look-back periods to recover refunds. I don't know if you see that out here. But if you read the law that deals with 6-year look-backs, it talks about CMS's ability to do a look-back with the plan, not the plan's ability to come to you 6 years back. And so we've requested FOIAs on different items that are just perplexing for us. You have a right to request under the Freedom of Information Act the same thing. Then, of course, in this same thing, same request, we wanted a written CMS policy, procedure, manual, or document that informs healthcare providers that CMS does not have regulatory oversight of MA plans that they contract with, and that the provider contract will control. They also provided something here that we now use against them because clearly the law states that CMS has an obligation to accept any complaint regardless of if you're contracted. And if you are contracted, they will review the policies and procedures of the plan to see if they're following their own procedures set in stone that should be consistent with Medicare law. So the first thing they don't want you to know is you can request a FOIA for anything that they do, any practice they engage in that impairs your ability to provide medically appropriate care. Number two, I'm noticing that there's a challenge of observation versus inpatient determinations. I want to talk about that just for a moment. Observation versus inpatient determinations. So what we're seeing in different states is the plans are taking an admission stating it did not meet interqual for admission, changed to observation. Are you seeing that as well? Okay, all right. And most of them are making this request after the patient is gone. Are you seeing that as well? All right. And we've begun to now look deeper into this to figure out how we would challenge the observation versus inpatient determination. A few things. Number one, remember earlier I gave you this under 42 CFR 422.113. In your cheat sheet, you can write emergency observation. Just write emergency observation in your cheat sheet. And then next to that, you can write 42 CFR 422.113 B3. I gave you this law first. The physician treating the enrollee must decide when the enrollee may be considered stabilized for transfer or discharge, and that decision is binding on the MA organization. We're talking about emergency observation. The first thing we talked about that payers don't want you to know is about the Freedom of Information Act. The second thing they don't want you to know is how to challenge emergency observation. Number one, the treating doctor determines stabilization, and whatever decision they make, that decision is binding on the MA plan. Number one. Number two, write this down, 42 CFR 422.101. I'm giving you a foundation of how to challenge observation denials. 422.113 B3 states that the treating doctor determines when the patient is stable for discharge or when they have to be admitted. That decision is binding on the plan. Section 42 CFR 422.101 states this, that the MA organization must meet the following requirements: provide coverage of, by furnishing, arranging for, or making payment for all services covered by Part A and Part B of Medicare. So we know that Medicare Advantage plans must cover what original Medicare would cover. Further, they must comply with CMS national coverage determinations. Number two, general coverage guidelines included in original Medicare manuals and instructions, unless superseded by regulations. All right, so when we go and train with a provider, we give them a book like this, and each color represents a law section. The pink section is Medicare Advantage law. There is nothing in the Medicare Advantage section that covers observation. So because nothing is governed, nothing talks about observation denials in the Medicare Advantage part, we must look to original Medicare rules. Does that make sense? All right, let's talk about that. The Medicare Benefit Policy Manual, write that down. We're talking about emergency observation. The Medicare Benefit Policy Manual, Chapter 6, Hospital Services covered by under Part B. It defines observation care as a well-defined set of specific clinically appropriate services, which include ongoing short-term treatment, assessment, reassessment before a decision can be made whether the patients will require further treatment as an inpatient or if they're able to be discharged from the hospital. Observation status is commonly assigned to patients who present to the ED. You can also see observation through a direct admit. You can also see observation after a surgery, but most of them are patients who are coming through the ED. So for that purpose, we're only talking about observation denials that stem from the ER, okay? Notice under that same section, it says observation services are covered only when provided by the order of a doctor or other individual authorized by state law or hospital bylaws to admit patients to the hospital or to order outpatient tests. Write this down. Section 50.3.1 of the Medicare Claims Processing Guide. We're just building a foundation for observation denials. Section 50.3.1 of the Medicare Claims Processing Guide, Chapter 1, says this: under the hospital COP, patients are admitted to the hospital as inpatients only on the recommendation of a physician or licensed practitioner permitted by the state to admit patients to that hospital. In addition, every Medicare patient must be under the care of a physician or other type of practitioner listed in the regulation. In some instances, a practitioner may order a beneficiary to be admitted as an inpatient, but upon reviewing the case, the hospital's UR committee, write that down. Every hospital should have a UR committee. They determine that the inpatient level is not medically necessary. The state operation manual states that in no case may a non-physician make a final determination that a patient's stay is not medically necessary. So a few things we want to just remember as we're building this foundation. Number one, the treating doctor determines stabilization under Section B3. Under this chapter of the Medicare claims processing, it says a non-physician may not make a final determination of a stay not being medically necessary. If they're asking me to change the denial from inpatient to observation, who's asking me? Is it a non-physician? Is it someone that's qualified? Who's asking me to change it from what the doctor ordered that's binding, right, to observation? Is it a non-physician that's making that request? So we're just trying to create some angles here that we can fight the observation challenge. Notice under that same section, it states this: in cases where a hospital or the UR committee determines that an inpatient admission does not meet hospital inpatient criteria, the hospital or the critical access hospital may change the beneficiary status from inpatient to outpatient observation or submit an outpatient claim for medically necessary Part B services that were furnished to the beneficiary, provided all of the following conditions are met. Number one, the change in patient status from inpatient to observation is made prior to discharge or release while the beneficiary is still a patient of the hospital. Number two, the hospital has not submitted a claim to Medicare for the inpatient admission. Number three, the practitioner responsible for the care of the patient and the UR committee concur with the decision. And number four, the concurrence of the doctor and the committee is well documented. So we've been challenging observation for a while, and it goes back to even 2014 when we were challenging observation issues. And we were concerned because if there was going to be a change from inpatient to observation, it was going to create an increased rise in liability for the patient. We were concerned about that, and we wrote to CMS in regards to that. And here's what we begin to just say to their office in Maryland, I believe, over appeals. In the second paragraph, in the past, we've been discussing the issue of Medicare Advantage plans requesting a provider change the status of the patient after discharge from inpatient to observation. It's been shown that this request may be impacting a beneficiary's access to care, and it's our understanding that Transmittal 50.3.2 of the Medicare Claims Processing Manual prohibits this kind of request after discharge of the patient. Mr. Albion, who works for Medicare, informed me that this section of the Medicare Claims Processing Manual only pertains to fee-for-service plans, but has not provided any statutory authority that supersedes the Medicare regulation. As previously requested, please provide the statutory authority that supersedes this regulation and allows a Medicare Advantage plan to request that a provider change the status of the beneficiary after discharge. And as we're looking into some of this, we notice that CMS couldn't provide anything to us that would be listed in the Medicare Advantage section that would supersede what I've just given you. And we've just shared with them, until you provide that to us, we will continue to direct our provider members to use original Medicare rules that prohibit the practice. So when the plan states they can ask you to change inpatient to observation, what will you ask them? Oh, I love it. Please provide the statutory authority you rely upon to request that we change the inpatient to observation in light of what the treating doctor ordered, number one, and after the patient. We're learning how to build a foundation here really well. Here's some application. Ask your payer to provide that statutory authority they rely upon to request the patient's stay be changed to observation, reflecting the change in what the treating doctor ordered that violates 42 CFR 422.113B3, and of course, after the patient discharge, which are under the original Medicare rules we spoke about before. So number one, what do MA plans don't want you to know? They don't want you to know about the Freedom of Information Act request. Number two, how to challenge observation versus inpatient denials. Number three, they don't want you to know that CMS views treating doctors as the plan. We talked about that earlier today in the keynote session. Here's the law again, in case you missed it. 42 CFR 422.113C2 states that the MA organization is financially responsible for services that are pre-approved by the plan provider or other MA rep. We talked about that Medicare manual document that CMS sent to us, and where they typed at the very bottom of it through Seema Verma's office, they typed this section that states when a treating doctor is contracted with the plan, CMS views him or her as the plan. for the purposes of their rules and guidance. We talked about what that would mean for us and how later in the CMS Medicare manual, it strengthens what they gave us through that FOIA request under 160 beneficiary protections related to plan-directed care. Watch this. So anything that's plan-directed protects the beneficiary. Plan-directed is MA rep-directed or a contracted provider with the MA plan directing that care. So we understand that CMS considers a contracted provider an agent of the plan. Let me add something. So we talked, they typed this. Here's what CMS typed to us. When a treating physician is contracted, CMS views him or her as the plan. But notice, the document that we requested from in our FOIA, it doesn't say the word physician. What does it say? Contracted provider. Now, we're testing this, or even if the treating physician wasn't contracted, but if the hospital was contracted, we're challenging it based on the hospital being contracted. Now, we're testing it because when I was in the hearings, we were only discussing the treating physician, the contracted physician. But in the rule, it says contracted provider. You can even find the definition of contracted provider in the Medicare manual and list yourself as a contracted provider, which would constitute a favorable determination of what was ordered by your hospital. Just throwing it out there, okay? We talked about how under medical necessity, there's some things listed, and I didn't have a chance to go over this upstairs. I'll go over it now. Under the Medicare Managed Care Manual, section 10.16, it says every MA plan must have policies and procedures, coverage rules, practice guidelines, payment policies, that allow for individual medical necessity determinations. No denial strictly based on a guideline. They must conduct individual medical necessity determinations. If a plan is not doing that and they're relying strictly on interqual or MCG, you could request a copy of their policies and procedures under 42 CFR 422.112 A6 II. In your cheat sheet, why don't you write that? Requesting policies and procedures from plans. Then list that section of law, 42 CFR 422.112 A6 II. 42 CFR 422.112 A6 II. So you can request their policy and procedures. Every plan that would make a request to change inpatient to observation, you can request their policy on that to see if it's consistent with the Medicare policy. Notice every MA plan must employ a medical director who's responsible for ensuring clinical accuracy of all decisions and reconsiderations involving medical necessity. That medical director must be a physician with a current and unrestricted license to practice medicine in a state. Notice if, number 3, if the MAO expects to issue a partially or fully adverse medical necessity decision, based on the initial review of the request, the organization determination must be reviewed by a physician or appropriate healthcare professional with sufficient medical and other expertise, including knowledge of Medicare coverage criteria. I gave you a law for that as well upstairs that talks about competency. It was 42 CFR 422.590 G 590. I'm going to pass this book around so you can see section G. I'll come this way and go all the way around. Section G G1 and 2. You can take a picture of that too if you'd like. That's the section that deals with competency. And we'll pass it all around where you'll have a chance to see it as well. Notice the MA plan also must make determinations based on the medical necessity of plan covered services, including emergency, urgent care, post-stabilization, based on internal policies, including coverage criteria, no more restrictive than original Medicare. Because remember, they must cover what original Medicare would cover, right? Pursuant to what law? What is it? What law states they must cover what Medicare must cover? I just gave it to you earlier. 422.101 talks about them making sure they cover what Medicare would cover. Watch this. Notice it must, I want you to hear this, including coverage criteria no more restrictive than original Medicare's national and local coverage policies, reviewed and approved by the medical director. And number two, where appropriate, involvement of the medical director and the enrollee's medical history, diagnoses, conditions, functional status, physician recommendations, and clinical notes. Those are all the things they must consider when they make a decision based on medical necessity. You'll find that many of them don't include all of these things listed. Do me a favor, I didn't give it earlier. On the bottom of your PDU form for registration, on the bottom of it, just write for me to send section 1016 for medical necessity. I'm going to send that to you because I want you to make sure that your medical necessity decisions are being based on all of these things listed in the manual. You can even create a medical necessity checklist based on those items that each of your reviewers has to go through to see if that denial contained what's listed here. I encourage you to do that. And then we read this later. Furthermore, if the plan approved the furnishing of a service through an advanced determination of coverage, it may not deny coverage later on the basis of a lack of medical necessity. So we're talking about how to challenge issues, how to create professional boundaries, how to discover rules of just conduct, how to know what the payers can do and what the payers cannot do, how to look at a denial notice and determine if it met the criteria we've just read, or if it was simply a denial based on medical a guideline without a clinical review that didn't include the diagnosis, a physician recommendation, etc. We talked about how we're challenging that using the fact that CMS considers contracted providers as the plan or agents of the plan, and how if a contract provider orders an item or service, it constitutes a favorable organization determination. We've talked about how to use the screenshots from the doctors going into the plans, going into SCAN and Humana and Kaiser, UHC, and looking up our doctor to see if they're contracted, using that when challenging their denials. We learned upstairs that plans have 1 hour to respond to a request for an authorization. Just for a moment, let's talk about peer-to-peer timeframes. Peer-to-peer timeframes. Let's discuss that just for a moment. Do I want to show you? One moment. I need to just look at something to see if I want to show you something that you need here. Is this it? Yeah. I'll show you this in just a minute. In a minute, I'm going to show you an observation case study of how we've used the law against the plans. Peer-to-peer timeframes. So we know that plans are financially responsible based on what we learned upstairs for services they don't pre-approve by a plan provider or MA organization rep if they don't respond within 1 hour of the time frame. So if you weren't upstairs with us, this law deals with post-stabilization timeframes in your cheat sheet. Just right, post-stab timeframes. Here's the law that you would add: 42 CFR 422.113, which indicates they have 60 minutes to respond to a request for pre-approval. They're also financially responsible if they cannot be contacted. If for some reason it's after hours, it's a Saturday, it's in the evening time, it's a holiday, they're responsible if they couldn't respond to you within 60 minutes in that setting. And then, of course, if they don't reach an agreement with you, they're financially responsible. And we gave you the criteria that you would look at if for some reason the plan did not pre-approve care, which included the plan assuming care of the patient with privileges at your hospital, assuming care through transfer, or reconsidering and giving you an authorization. If they don't do that, they have to pay you up until discharge. It's really important when you're dealing with peer-to-peer issues. Just by a show of hands, how many of you have a peer-to-peer process in your hospital? How many of you have one? All right, so if you don't have one, I'm assuming that you don't have one. So for those of you that didn't raise your hand, do you do concurrent reviews with doctors and the hospital, or and the plans rather? You do that. Who does them? Is it a treating doctor in that sense? Okay, got you. So what we're seeing is some plans are stating we won't do it with a physician advisor. We'll only do it with the treating provider, which actually is supported by the law, by the way. But the law also states if you can't reach an agreement or if you cannot meet, that the plan must assume care of the patient. Sorry, if you cannot come to an agreement, if you cannot do a peer-to-peer review, you can continue treating the patient, and the plan can assume care for the patient through a doctor with privileges or through transfer, or reconsider and give you an authorization. If they don't do any of those, they're responsible through discharge. So even if you don't have a physician advisor, or if you have a physician advisor and they're being refused the peer-to-peer review because they're not the treating provider, you still have an angle to challenge these type of denials. And I just want you to make sure that you see them. You understand that this section is very, very clear under C2 III, that they're financially responsible if you cannot reach an agreement concerning the enrollee's care, or if someone isn't available for consultation. They must, in that scenario, take over care if they're going to concurrently deny the patient's further hospitalization at your facility. So just remember that as you're challenging them. If they're going to deny it concurrently, we learned upstairs, here's the fifth thing, we learned that concurrent patient denials must be transferred. So we've talked, number one, about how plans don't want you to know about the MA or the Freedom of Information requests that you can make through the FOIA. Number two, they don't want you to know about observation denials. We understand that that's an issue. We understand that they also don't want you to know, number three, about the post-stabilization timeframes. Number four, peer-to-peer reviews. That process, they don't want you to know that if they don't engage in the peer-to-peer review process, they're responsible to assume care of the patient. Number five, any concurrent patient denials must be transferred. This includes scenarios where you admitted them and they stated that the patient should have been in observation. I'll show you in just a minute. This outlines the end of the organization's financial responsibility. And we talked about it earlier upstairs under 422.113 C3, that they have a responsibility to come and get the patient or give you an authorization or pay up until discharge. Let me just show you quickly how that looks. I'm sending a book around to you right now that includes this section of law. If you didn't write this down upstairs when we were meeting, you can write it now. 42 CFR 422.590 G2 talks about how any medical necessity denials must be made by a doctor with expertise in the field of medicine appropriate for the services at issue. Now, I said all that to say this. I want to show you a case study of how it works, how we've put it into action. Here's how we file complaints with CMS. We talked earlier about the region map that we discussed. There's that region 10 that someone shared with us earlier for Oregon. Here is a fax or a dispute cover sheet that CMS created for our provider members to file complaints with their regions. Here's an example of what we did. Notice they'll give you a place where you can list complaint type. They also want to know, where is it at? Provider contract status under 1.110. So they want to know if you're contracted or if you're not contracted with the Medicare Advantage plan. Keep in mind that if you're not contracted, they may send you an email stating we don't get involved in private party contracts between MA plans and providers. You have to remember that your response to that, if they try to close that complaint for that reason, would be under 42 CFR 422.504. That law outlines CMS's responsibility to govern the contract they have with the Medicare Advantage plan. So notice we listed also, they give you a small area for brief summary of complaint. And one of our reps wrote this: patient arrived at the ER. Him had attempted to make notification to Molina Sr. of a possible inpatient admission. Molina failed to respond to the 1 hour allotted per Title 42. Patient was admitted due to no response from Molina. We then got a response back from the doctor at Molina who wrote to CMS, and CMS sent this to us. Here's a copy of the complaint number, CTM complaint number. They wrote this: to whom it may concern. The case has been reviewed. The following documents were reviewed for this case, and they list here that they looked at the patient medical record number, the CTM complaint that we filed, medical records that were 22 pages as well. They wrote this: the Hemet Valley Medical Center has filed a grievance regarding this case, and they've stated that Molina failed to respond within 1 hour to the request for an authorization. Per the provider dispute, the provider did not file a medical necessity complaint. Therefore, Molina concludes that the facility does not dispute the case on the basis of medical necessity. Regarding the 422.113 regulation and the allegation that the hospital called Molina, Molina did not respond to the notification call within 1 hour. The records submitted by the provider do not support the allegation. The medical records submitted to Molina did not show evidence of any attempted communication between Hemet and Molina prior to the member being admitted. The dispute by Hemet, therefore, is without merit. All right, for a moment, how would you fight this? They're saying you provided no evidence, you made contact. Therefore, you can't use the 1 hour rule. How would you fight it? Say again? What kind of evidence? Very good. What kind of evidence could we give a payer showing we made contact? Oh, talked about that, right? Because they're not giving you a tracking number, because an authorization creates a contract, right? But the tracking number does constitute that contact was made. You knew the patient was here. So I didn't just make up the tracking number, right? This is your tracking number you gave on this date. So number one, tracking number. What other kind of evidence? Love that. Fax confirmation. So write this down. When we fax payers for authorization, where are we storing our fax confirmations? Showing we made contact. Not just the tracking number. Here's the fax cover sheet showing that it went through on this date that you got, right? What if you called them? What could you use? Call reference number. You can use remote screenshots of what you entered into your system. Write this down. Under the Federal Business Records Act, anything you create in the course of business, including hospital notes, is deemed truth of the matter you're asserting. Under the Federal Business Records Act, you can take your notes and say, according to our notes, we talked to Jane D at this phone number who stated, here's a tracking number, and you can use the Federal Business Records Act to invoke those documents as reliable information. So tracking number, fax confirmation sheet, notes, and the call reference number using the Federal Business Records Act. That's our evidence, right? That we're going to provide them. So here's little Rose. She's a non-physician. By the way, this was a doctor, Dr. James Cruz, who wrote this letter. Here's little Rose. She's non-physician. She's just a coder, senior person in our office over revenue integrity, skilled in billing. And she writes this, Miss Munoz, thank you for reaching out to us. I've reviewed the Dr. Cruz's August 11th, 2017 letter. We dispute the comments he made to CMS as inaccurate. It's apparent that Dr. Cruz was unaware of the events that had taken place prior to post-stabilization services being requested by the treating doctor. In Dr. Cruz's correspondence, he states what we listed in our complaint. Patient arrived in the ER, tried to call you. Molina failed to respond within 1 hour. Per his correspondence to CMS, he further states there was nothing Hemet submitted to support the allegation of Molina's failure to respond and violation of 422.113. We respectfully dispute his response. Upon stabilization of the emergency service, Hemet faxed 4 requests for inpatient authorization for post-stabilization care to Molina and Vantage Medical Group. On 3/29/16, both Vantage and Molina provided a tracking number. At no time, by the way, here's the tracking number that you provided. At no time did either entity authorize services within 1 hour of the request. The tracking number constitutes that contact was made even if it's not an authorization. At no time did either entity request a transfer of the patient, nor attempted to assume care of the patient or member. We're unsure what Molina assumed would happen to the patient without a timely response, especially since the treating doctor deemed the patient appropriate for admission. Here, Molina is attempting to act as traditional Medicare to perform retro reviews, yet they're a Medicare Advantage plan governed by all of this section of law. Please order them to release the federal funds due the Medicare beneficiary. She wrote this on March 16th, 2008. Well, after that, Molina's attorney got involved. And the attorney said, to whom it may concern. Molina takes issue with the legal basis for this complaint. In the complaint, Hemet makes a very critical mistake of taking a portion of a regulation out of context to support their position. Hemet claims Molina's in violation of 113, stating that we didn't respond within 1 hour. But had Hemet included the entire citation, it would become clear this situation only applies to services administered to maintain, improve, or resolve the enrollee's stabilized condition. Per 113, post-stabilization care are provided in order to maintain a stabilized condition or improve or resolve the enrollee's condition. It is and always has been Molina's position, watch this, that an inpatient admission was not necessary to maintain or improve the enrollee's condition. What was he trying to say there? An inpatient admission was not necessary to maintain, improve, or resolve the enrollee's stabilized condition. And for the most part, he's saying if an inpatient admission wasn't necessary, the patient could have been seen observation, right? This whole fight was over observation. Moreover, Hemet has not disputed Molina's decision by filing a medical necessity complaint. Notice they kept trying to pull the provider into fighting medical necessity. But that wasn't our fight. What was our fight? We called you. You didn't respond within. The patient was discharged. You're financially responsible up until discharge. That was our position. So we then noticed that they stated Hemet has not disputed Molina's decision by filing a medical necessity complaint as is required. Therefore, since Molina determined the services were not medically necessary, the 1 hour rule cited by Hemet would not apply here. If Hemet's understanding of the law was correct, then it would significantly undermine our ability to do our job effectively, because we would no longer have much ability to control inpatient admissions following ER visits. 1 hour is hardly enough time to receive a fax, perform a competent clinical review, and respond to the hospital. If the failure to respond within that time frame meant that the hospital was right, automatically correct, it would lead to abuse. That's why Molina's interpretation of the law seems to align more closely to what we can assume the drafters intended and what would make best public policy. Nevertheless, Molina responded within hours of the fax, requesting clinical information, hardly an unreasonable amount of time. So if they responded within hours, right, and stated they needed clinicals, and they received the clinicals, what was their responsibility before the patient left if they wanted to deny it? Come get your patient. No, first, deny it. Because sometimes they ask for clinicals, they say nothing until the patient's gone and you bill them. Then they tell you, we denied it for medical necessity. That's a problem. Because as long as they do it after the patient's gone, you can't enter into a disagreement of care. The disagreement of care you're able to enter into takes place after or while the patient's in house, so you can trigger their responsibility to come and get the actual patient. So he said we responded within hours. Therefore, since Hemet's not disputing medical necessity, since the 1 hour rule referenced by Hemet does not apply to these circumstances, there are no further issues that need to be considered. We ask for their claim to be dismissed. That was on March 22nd, 2018 by Ryan Cawley, an attorney in utilization management. The plans are putting attorneys in utilization management. Watch that, okay? Look at this. Here's little Rose. She's a non-clinician. She's a non-attorney taking this attorney to town. She writes this: good morning, Mr. Cawley. We're in receipt of your correspondence addressed to CMS. You state that Hemet claims Molina was in violation for not responding within 1 hour. You then stated that Molina responded within hours of the fax, hardly an unreasonable amount of time. Our position is clear. The 1 hour time frame is to benefit the patient, not you, nor the provider. Patients need access to care quickly, and this regulation holds both parties accountable hardly an unreasonable amount of time to avoid catastrophic consequences. Hemet's interpretation of the law is accurate. We agree. It appears Molina is interpreting the law to benefit itself. Even if Molina felt it's not provided enough time, there is no statutory authority that exempts Molina from adhering to it. Molina must perform according to the requirements, which are 1 hour. This can become burdensome on providers, yet they still send requests for authorizations diligently. You then state, Had Hammond included the entire citation, it would become clear that this situation only applies to services administered to maintain, improve, resolve the enrollee's stabilized condition. Please advise why a treating doctor would admit a patient for post-stay services and care other than to maintain, improve, and resolve the stabilized condition. If Molina disproved the care, you failed to attempt transfer prior to discharge of the patient. If you responded within hours, we are unaware of any intent to transfer the patient. Patient was admitted from 3/28 to 4/2/18. I do not see a transfer request or denial of care prior to discharge. She then quotes the law again on March 28th. And then after this, she states, she applies it. Here, Molina failed to assume care within 1 hour, which means their financial responsibility ended when the patient was discharged. Please be advised, you're really bad. Other hospitals are saying that you're bad. Stop it. And she said all that stuff. That was on March 28th, 2018. Well, so we've heard from a peer reviewer. We've heard from an attorney. Rose has combated both of them. The last response is from the Chief Medical Officer, Dr. Tyler Jung. To whom it may concern, this claim has been reviewed by our Chief Medical Officer, Tyler Jung. After careful consideration and applying applicable clinical criteria and judgment, the denial in question has been overturned. Then he gives us all the medical reasons why they overturned it. Why do you think he did that? Why do you think he gave us a medical justification of why it was medically necessary? I gave it to you upstairs. 42 CFR 422.166 states that they can have their star rating affected by complaints that providers file. So rather than admit he violated that 1 hour rule, they simply made it a medical necessity issue. Now, do you remember that both the first doctor and the attorney stated that the provider did not send what kind of appeal? Do you remember? Medical necessity appeal. So can we agree that at no time did the provider or our office send a medical necessity letter stating why it was medically necessary? Can you agree with that? But yet, when they overturned it based on, did you just see that? They overturned it. That means they should have never denied it. And if we hadn't fought 1 time and 2 times, they would have kept their denial upheld. If we hadn't escalated that to CMS, they would have never resolved it. These are the reasons why we must fight our providers, our payers that challenge our providers. These are the reasons why we must have the ability to ensure that we protect patient access to care. I'm finished. I'm literally done. Seriously. Now, a few moments. I didn't have a chance to do it upstairs, so I am going to take questions from you here, if that's all right. Yes.
So the situations we've talked about are ones where there's
Microphone right there.
situations we've talked about are ones where there's a requirement by the payer for an authorization.
Uh-huh.
If there's no requirement for an authorization, is this all open and subject to retrospective review?
Oh, great question. When you say there's no requirements, are we still calling and they're telling us no authorizations required? Is that what you're meaning in that scenario?
Yes, or we already know that their policies that they don't have.
Gotcha. So a few things. The scenarios I've shown you only deal with emergency admissions. The authorization process is only for emergency admissions. All right. So it's important to recognize that if for some reason you're dealing with another type of service that you're trying to get authorization, that section will not apply to you. And they could come back and try to engage in a retrospective review. When you say we already know, that they're not going to authorize it. Are you getting denials later stating it was denied for lack of authorization? Okay, all right. So these are scenarios where that authorization isn't required. They're not denying it later for lack of authorization. They're denying it for lack of medical necessity. All right. So we're going to use in that scenario, I'm going to send you section 10.16 that talks about medical necessity decisions. That section I gave you governs any care. Whether emergency or not, they must follow those guidelines for authorizations, providing you with policies and procedures, etc. They must follow section 590G that you saw probably earlier, if they're going to make a decision from that's not medically necessary. So I think you'll be able to use both section 10.16 and 590G when you're challenging and pushing back a medical necessity denial. Keep in mind, most providers, when they fight them, they fight through care coordination, they fight through a doctor, they fight through the medical records. All I'm saying is, if you're great doing that, how will you look when you blend the law with that process? When you blend the law with clinical background or knowledge to challenge medical necessity? Great question. Any other questions?
Do we get the presentation?
Yes, I've given it to HFMA. You can certainly, you have a copy of it on PDF. You have the ability to refer back to it. Absolutely. Absolutely. Questions? Medicare Advantage or anything? Yes.
Have you done any work with post audits where they audit your charges, determine that certain charges are not separately billable?
Okay, got you.
And is there any, if you have, is there any legal arguments?
Can you give me an example of the type of service they've denied for that reason? I heard someone else mention it over here, so I think someone else has dealt with it. What type of service are they denying?
I just worked on a UHC case.
Okay.
Where the mayor decided to disallow certain charges based on the fact that they thought they should be part of other charges that were on the claim. Like, for example, certain nursing charges that were nursing drug administration charges in the
Sure.
emergency room should be part of the room and care charge.
Got it.
As the patient was admitted.
Got it. Got you.
And they were using provider reimbursement 22, 24, or something like that.
Got you.
To defend that.
So I have a person in my office. In fact, she's the one that worked on this case. Her name is Rose Trochez. If you look on my business card, you'll see my email address that says ednorwood@Earn Enterprises. Rose Trochez, if you replace her name with mine, Rose would have probably a great answer. She's probably seen that more than I have because she does a lot of she's our revenue integrity senior officer. She does a lot of those denials within our structure. So if you could email that to her, she probably has some foundational things that she's used to challenge those, but I personally have not worked those cases. Great question though. For those of you that have, I heard someone else mention this though, please write Rose's information down. She's phenomenal. She's like, I tease her. She's 100%. Every client I've given to her and provider member I've referred to her, 100% of the time she's been able to find an answer for them. Now, knock on wood, hopefully that doesn't change, but she's been 100% for me. Here's her email address. It's the same as mine. The name is ROSE Trochez. T as in Tom, R as in Robert, O as in Oxford, C as in Charlie, H as in Harry, E as in Edward, Z as in zebra. Rose Trochez at Earn Enterprises. She'd have some great insight on what you're saying just based on the work that she does in our office. Any other questions? All right, so a few things. I'd like you, if you have a PDU certificate form, please turn that in to me before you actually leave. Keep in mind that we're engaged in several fights with CMS right now, and I'm going to email you from today's session. I think I promised you from upstairs and downstairs a UR fax cover sheet, a documentation and rebuttal guideline. I believe I also promised you something else today. I promised you. Oh, that's right. The Medicare manual that we obtain in the FOIA request, section 10.16 on medical necessity. I'm going to give you that. That will frame how you can create a checklist for medical necessity denials. It's really important that you create something like that. We have created a request for medical records checklist to determine when we'll give medical records, when we won't. Let me end with this. Some time ago, I posted something on the HIPAA minimum necessary rule that talks about the number of medical records or the type of medical records plans can request from providers, because we've seen them make unnecessary requests for medical records. We use the HIPAA privacy rule when we're combating medical necessity requests, but we also use the HIPAA privacy rule when we see that a plan has received clinicals but stated to you they didn't get the clinicals. Let me see quickly if I can show you this. Mm-hmm. We use this for both when the plan says no claim is on file and when no records were on file. Even though you have documentation, you submitted the records. Number one, we tell them that the claim or the records are presumed to have been received. And if we mailed anything to them, if we uploaded them, we'll say this claim or the records were submitted to you through our claims clearinghouse and not rejected, or the records were faxed on a secure line successfully with a fax confirmation sheet. If they were mailed, we'll tell them under the common law mailbox rule, proper and timely mailing of a document properly addressed and deposited in the U.S. Postal Service raises a rebuttable presumption that it is received by the addressee. If they've lost the claim or the records, we tell them that they mishandled PHI. And we will fax you a copy of the claim or the records you lost. Because we've got the confirmation, we show it went through, it uploaded with no problem. Then we created this disclaimer as well. You're reminded that this office is monitoring any possible HIPAA violations that may have occurred due to the mishandling and possible loss of claims and or medical records. The HIPAA privacy rule requires a covered entity to maintain reasonable and appropriate administrative, technical, and physical safeguards to prevent intentional or unintentional use or disclosure of PHI in violation of the privacy rule. Please process this claim or authorization on a rush basis. Then we quote 45 CFR 164.530C. This is for lost records, lost claims, 45 CFR 164.530. 45 CFR 164.530C. Now, I share that for this reason. I know the games sometimes that are, go ahead. I tell you what, if you want that on the bottom of your form, just put send no records on file infographic. I'll send that to you, okay? And you can give that to every member of your team that gets that stall tactic often. I'll leave you with this. We at Quorum Health who use this. They came to one of my sessions where I was training about maybe 300 doctors and nurses, and they wrote this to me after using this strategy. My VP and myself attended one of Ed's talks last year, and we're excited about the things we learned. The one with the biggest impact for our hospitals has been the HIPAA terminology. I must say that I was skeptical when Ed shared the idea of utilizing HIPAA terminology with payers that claim to have not received clinicals. I assumed the payers would ignore this and continue to play the games they have been playing. I was wrong. I shared this technique with case management at our hospitals, and within days, I was receiving emails singing the praises of this. The directors were amazed at how quickly the payers were changing their story and authorizing all days once they were notified we were going to report the HIPAA violations to the OIG. Now, you can't file a complaint with the OIG in regards to this. You can file a complaint with the Office of Civil Rights when they mishandle patient information. So you would simply use this same strategy. He ends by stating, it was definitely a great piece of leverage for our hospitals. Thanks. And that's just by him using this little disclaimer here, along with the federal law. So I encourage you. What I've done in this session and upstairs is simply give you tools that you can use to challenge payers. But now you can't just stop here. I'm going to send you some things that will inspire you to create more tools. Some of you, I have the privilege of meeting in person and doing training with your staff, but the reason why people asked me years ago, why do you give people all this information? Because we believe that the laws that we taught you today, upstairs and downstairs, were enacted not for Ed's good, but for public good, for you, for your provider, for your patients. And we would not dare engage in a relationship with our provider members without ensuring that they're empowered, that they're equipped with the tools in the arsenal to work in concert with us. Because if we represent you, we don't want to reject the medical records, then they call someone in your office and you give them medical records. We want to show you why, in what scenario we'll tell them, sorry, your request for medical records has been denied. Please be advised, you were contacted January 15th. We asked for an authorization. You failed to respond within 1 hour. Patient was discharged, which marked the end of your financial responsibility. I was with a provider recently who said this to me. He said, Ed, we have a workflow where we can't do that. My CFO would go crazy if we challenge that concurrently. We let it go all the way to the back end, then we deny it. And then we give them medical records, by the way. How do I use this in the midst of that workflow? I said, okay, great. We're going to put together a cover sheet with every request for medical records. It's going to state this. Attached are the medical records you requested on this date. However, please be advised on January 15th, we called you. You failed to respond within 1 hour per 42 CFR 422.113C. The patient was discharged on 1/20 without any disapproval from you, marking the end of your financial responsibility. Therefore, these medical records are submitted to you to price and pay the claim, not for you to conduct an improper medical necessity review. We just changed it. So every challenge forces you to be innovative and to change. And in today's industry, change is necessary for growth. Thank you. Have a great conference this week. Thank you. If you have your registration, your PDU form, please bring it to me. I'll make sure we get those documents to you. If you have team members that didn't give it to me, they can email that to me as well.